pretrial motions to be argued today. Some have been agreed to with the solicitor. We'll put those on the record later. But the first one that we have pending is a motion to dismiss the indictment on the grounds of double jeopardy, due process, and cruel and unusual punishment. And Mr. Shealy will be arguing for the Mr. Slager.
Okay.
May it please the court, Your Honor. My name is Miller Shealy. I'm here on behalf of Michael Slager, and I appreciate you allowing me time to make some of the legal arguments involved in this motion to be sure that the record is adequate. I'll be arguing most of the law today on this point. First of all, Your Honor, I would point out that we are entirely aware of the United States Supreme Court precedent on this, and we have cited it in that motion. Despite that, we think we have grounds to ask the court today to dismiss the indictment. And for the record, I want to be absolutely clear of the three bases that we're asking the court to dismiss the indictment currently pending in state court. First of all, we're asking that the court dismiss the indictment based on the due process clause of the federal constitution and the state equivalent, the cruel and unusual punishment clause of the federal constitution and the state equivalent, and the double jeopardy clause of the United States Constitution and its state equivalent. We believe that all three of those grounds are the basis for dismissing the indictment. We are here today, and Mr. Slager is also in federal court. There's an indictment pending in federal court. It's been pending for some time. Both indictments, both the state indictment and the federal indictment, arise out of the same course of conduct alleged to have been committed by Mr. Slager. The basis for allowing the prosecution to proceed simultaneously, which is not totally unusual, but a bit so, because usually one follows the other. Nevertheless, both prosecutions have been proceeding simultaneously, and discovery motions have been made in both federal and state court, and discovery has been exchanged by the state and the United States government and the defense team in this case. And that continues to go on as we speak. And the federal investigation certainly continues to go on, and the prosecution. Your Honor, first and foremost, just to lay the groundwork, current practices in terms of law enforcement in this country, in many cases, especially major cases, have changed. And we've cited a lot of authority for that, legal authority, in our motion. State and federal law enforcement work hand in hand rather frequently. They do in this case. That's not the issue. We don't have a problem with that. What we have a problem with is simultaneous joint prosecution at exactly the same time, precisely the same course of conduct, which is manifest here. But that is precisely what we believe is basically going on behind the scenes. And again, that's not like allegation or anything improper. I want to be very clear. They should work together, but it's the dual prosecution aspect. The dual prosecution is simply what the court has called an exception to what is otherwise the double jeopardy clause that allows for the prosecution to make the same course of conduct in two different courts. And the double jeopardy clause in the Fifth Amendment reads precisely so we get it clear, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. And we believe, Your Honor, that this language, as it is currently interpreted by the court, in many cases, that the double jeopardy provision in dual sovereignty is inconsistent with the goals and purposes of the double jeopardy clause that the court has set out now nearly for 50 or to 70 years. First of all, dual sovereignty as it's currently practiced in this country is unconstitutional. It is inconsistent with the nation's legal history and precedent. It's contrary clearly to the common law in the United States and England. It is contrary to the legal practice at the time of the founders, and currently it is inefficient and terribly expensive and requires not just the dual application of resources in separate courts.
That's according
yes,
to
sir.
according to what legal authority?
I'm sorry?
According to what legal authority?
With respect to the expense and the things of that nature, we've cited a number of law review articles that catalog a lot of this. And basically, just like it is here, we have the same prosecution going on across the street, basically, for exactly the same course of conduct. So agents and witnesses in one case will be shipped across the street to testify, if that's all that's indicated.
And what authority is the dual sovereignty doctrine unconstitutional?
Your Honor, the basis of its unconstitutionality, we believe, is simply twofold. One, it's inconsistent with the common law.
I understand your argument. I'm asking
Yes.
under what authority, under what case authority, if it exists.
And I understand that the case authority of the United States Supreme Court now currently indicates that it is constitutional. What we are less certain about is that the United States Supreme Court has ever had squarely before it recently the precise facts of this case, as well as the history and the scholarship that's been done on the history of this clause, especially since Barkus versus Illinois and since Abate, both of which were in 1959. And those are two central cases, they're not the only cases, but when those cases were decided, the great expansion of federal authority occurred in most of those cases in 1959. An enormous expansion of federal authority in the 60s, the 70s, and 80s, especially with respect to criminal prosecution, did not occur. So that there's far more of this at this time. And we would ask the court to pay special attention. Several dissents, there are dissents recently pointing some of this out, and none of them are for the Supreme Court. Justice Black in 1959, in Barkus and in Abate, noticed the court on some of this, although we think a lot of information, historical information, was not before the court at that time. Judge Adams in U.S. versus Gibbons, in which we have cited, is also the same kind of case in his dissent. And Justice Calabresi has also cited the difference in what has happened in recent years with respect to joint state and federal prosecution and these kind of facts that are typical in cases such as this, where what we really have in substance, and again, this is not an allegation of improper conduct, it's just that they need to decide which court they want to be in. Is it two different sovereigns, or two different entities are having two bites at the same apple?
They need to decide which court they want to be in? Meaning-
Yes, sir. In other words, the issue is, we don't deny that there can be a prosecution, but there's a prosecution based on precisely the same course of conduct in two different courts. That raises not only, we think, double jeopardy concerns and problems with the application of dual sovereignty, it clearly raises due process concerns. Those, I'm not sure have ever adequately been expressed in the court, raised in this kind of context with respect to due process. Also, it raised true and unusual punishment concerns, because for precisely the same conduct, he's being punished twice. Both courts both proclaim punitive sovereigns.
Being punished prior to conviction?
Well, Your Honor, the reason why, with all due respect, I read the precise language of the Fifth Amendment, it does not guarantee protection from dual conviction. It does not guarantee protection from dual prosecution. It guarantees protection from being twice put in jeopardy of life or limb. And that's what happens when this court, when he is indicted, both the United States and the state government are saying he's in jeopardy at that point. He has to defend himself.
When does jeopardy attach?
It's going to attach when you swear the jury. It's going to attach in a bench trial when the first witness is sworn, and it is going to attach in a guilty plea when the court accepts the defendant's guilty plea. However, he has to defend long before that. He has to defend long before that as a practical matter. He's been doing so. And that's really the crushing part of this that we want to get to. Not only has state federal law enforcement changed, not only do they cooperate substantially, but as a practical matter, if you look at the American common law at the time of the founding, the English common law prior to that, and even this case from South Carolina, State versus Antonio from 1816, that's an old case.
What year?
1816, which we cited in our memo, because it's indicative of the common law. And the law at the time of the founding, law at the time of the Constitution was written, this notion that one would be prosecuted by dual sovereigns was generally not accepted. You could plead autrefois acquit, or autrefois convict, and that was a pleading at the common law to say, I've either been acquitted or convicted in another sovereign, not just the same sovereign. So we don't think that these matters have been squarely presented to the court as they should be in a case precisely like this, and it's not a follow-up prosecution.
The court, you mean any court in America?
The United States Supreme Court.
United States
We
Supreme Court.
believe this is a case, and the facts and circumstances of law enforcement and the way things are done have changed substantially since Abate and substantially since Barkus. So we think that this court, with all due respect, we understand what the precedent is. You yourself have asked me about it very properly. I understand that. But we think the court is bound by the Constitution primarily, and for that reason, the court should dismiss the indictment. And I just want to emphasize one more time very clearly the nature of the common law here at the founding in England and the United States. And the text of the language itself. He is already twice in jeopardy of life or limb by virtue of indictment. He has been defending actively in both courts. That's the problem. This is not a typical situation where once the state, the federal government prosecute, it's over and they're quit or whatever, and then the next one starts. They're going along on the same track, on the same two rails right now, which has been financially burdensome, emotionally burdensome, legally burdensome, both for the defendant and for the state, and we think it's unnecessary. And for all the reasons that it creates a double jeopardy problem and a dual sovereignty problem, it creates a due process and cruel and unusual punishment problem. It's very difficult to defend a case like this. It's extraordinarily expensive. And also the punishment that you will receive, and it's going to happen. That's why the time is right. The jury's picked. It's about to be sworn, the indictment's there. That's why we think the time is right. This motion is.
So what do you want me to do?
But actually dismiss the state indictment.
And then you go to the federal court and ask them to dismiss it as well?
Well, this indictment will be done, so we'll have a different argument from them if we have one at all. If we were in federal court, we'd be asking the same thing. But that's the sorry.
So you intend to argue the same thing in both courts?
If I may, that depends substantially on what you might do here today. If there's no indictment, then we have to come up with a different argument. But
have you filed the same motion in the other court?
Not yet, Your Honor. We did not, but we plan to do that. And obviously, we're in a bit more difficulty here because the jury is about to be sworn. That's not the case in federal court. We have some time. But the point is, the bottom line point is for due process and cruel and unusual punishment, is that this is the same precise conduct. It is a simultaneous prosecution. It's fundamentally unfair in the due process. It's cruel and unusual punishment because it's stacking for the same conduct. And we think the dual sovereignty doctrine is not adequately articulated so as to allow this kind of situation. We would also point out briefly that the court, in many of the cases we've cited, the policy bases for the double jeopardy provision, there are a number of them. One is to prevent the government from using greater resources versus the defendant, wearing them down. The court is pointing this. This is why we don't allow successive prosecution. Protect individuals from financial, emotional, and social consequences of double prosecution. To guarantee finality of the proceeding, and to restrict the prosecution in their discretion from multiple prosecutions, basically having multiple bites at the same apple. And also the court has said that the defendants do have a right to know what proceeding what jurisdiction they're going to be tried in and what forum, and to have one forum. That's a valuable policy. Just have one forum. The dual sovereignty doctrine is at odds with many of the policy reasons set out by the Supreme Court that undergird the double jeopardy provision. Those policy reasons conflict, and that's one reason we feel we have to make this motion and ask you to dismiss this indictment. They conflict. Ultimately, the Supreme Court will need to resolve it, but they do conflict. And Your Honor, if there are no further questions, that's all I have at this time.
All right, thank you, sir.
Thank you.
From the state.
Thank you, Your Honor. I appreciate Professor Shealy acknowledging and very upfront about this, Your Honor. What they're asking you to do is to set aside the United States Supreme Court's interpretation of the Constitution and embark on a new venture here interpreting the Double Jeopardy Clause as it has not heretofore been interpreted. And the defense acknowledges that right off the bat when they speak to you. Now, Professor Shealy is very articulate and very learned, and he can certainly make a passionate and well-reasoned pitch to you, Your Honor, to do that. But I would state this: it's not really the role of a trial court to embark on such a new journey over new legal ground. Certainly in this case, as Solicitor Wilson has acknowledged several times, there have been discussions and cooperations between state authorities and investigators on this matter, but that's all it has been, is cooperation. Cooperation between state and federal authorities has been approved several times over by state and federal appellate courts, including the United States Supreme Court. Mr. Shealy points out that he thinks maybe the United States Supreme Court might feel differently now because Barkas was decided in 1959, which is of course true. That is not saying that federal circuit courts of appeal haven't addressed similar sort of arguments several times since 1959. Now, granted, I give the caveat that every case is a little different, But in each circuit, every circuit, and all of them have addressed similar cases where the defense has accused state and federal authorities of working too closely together and violating this dual sovereignty doctrine, and those have happened far more recently than 1959. If the court needs, U.S. versus Coker, First Circuit in 2005, U.S. versus Burden, Second Circuit 2010, U.S. versus Berry, Third Circuit 1999, U.S. versus Montgomery, Fourth Circuit 2001, U.S. versus Angleton, Fifth Circuit 2002.
What about
In all of these cases, the defense made an accusation that the federal authorities and the state authorities sort of violated the underlying purpose of the dual sovereignty doctrine by coordinating too closely together? I'll note I could go on. There's about 10 more. I count 23 cases where similar arguments have been made in the U.S. Federal Circuit Court, and in all 23, the courts have found that they have not established the fact that this was a violation of this dual sovereignty doctrine. What Professor Shealy does is bring together a lot of academic scholarship on the subject, and again, however compelling that may be on policy and academic grounds, that's not binding law. And the binding law here that binds this court and controls is that cooperation between the two authorities is approved of. He asked they need to decide what court they're in. Well, we're here in court, proceeding first on the state law grounds, and then possibly at a later date, they'll proceed under, as is their prerogative as a separate sovereign. The federal government may or may not proceed. But we're here today talking about what is mainly a double jeopardy argument before the first jeopardy attaches. So this is not a right argument. And in a lot of ways, getting into the substance of the motion is unnecessary. But I think Professor Shealy is incorrect as to the law that binds this court. And I think, furthermore, it's unright because we don't make double jeopardy claims before the first jeopardy attaches. When a double jeopardy claim is made, it's the government's job to prove by a preponderance of the evidence that the offense charged is not the same one for which the defendant was formally placed in jeopardy. No one in this room is pointing to any time that the defendant's formally been placed in jeopardy under the meaning of that, which is taken to trial. Not hardships pre-trial, not preparing a case. Double jeopardy is taken to trial when jeopardy attaches by the swearing of the jury, and we're about to do that for the first time. We would ask, for those reasons, that Your Honor deny this motion. We think it's unright and not supported by established law, Your Honor.
Your Honor.
Yes, sir.
Just briefly, Your Honor. Thank you. I just want to be very clear on one thing from the defense's perspective. Our motion is not keyed ultimately on whether or not there was, or to the extent that there was, federal-state cooperation. Let's assume there's none, and I think we all agree that if that's not the case, there's not none. There is some. How much it is, we may disagree on. If there were none, we'd still be making the motion. The due process, the cruel, unusual, punishment, and other reasons would still be there. So we have not asserted, we do not assert that there's anything improper or wrong with cooperation. It's just that they can cooperate. They just must decide whether they're going to do this in federal or state court. They don't get two bites to apple. That's all I'd like to clarify.
Sir.
Judge, I mean, it's been decided. We're proceeding now under state court, and what later objections they may have to them proceeding under federal court can be raised in front of the federal court. Again, that goes to the rightness of this issue. Having said that, I think the defense's basis for this motion certainly are preserved. The motion's been filed, and we've had this discussion, and I think it's time now properly to deny the motion and move forward.
The defendant has filed a motion to dismiss the indictment on the grounds of double jeopardy, violation of his due process rights, and cruel and unusual punishment. The defense argues that the double jeopardy and the dual sovereignty doctrine precludes this prosecution. As conceded by the defense, the dual sovereignty doctrine has long been held to be an exception to the double jeopardy clause. dual sovereignty doctrine permits two separate sovereigns to punish for the same conduct. In South Carolina, the double jeopardy clauses, state constitution, and also the federal constitution affords the defendant protections against a second prosecution after an acquittal, against the second prosecution after a conviction, and against multiple punishments for the same offense. In this case, the defendant has no double double jeopardy protection under South Carolina state law. The defendant has been afforded due process of law within the state through the many matters being litigated according to our law, the laws of this state and our Constitution. In effect, the defense is asking me to overrule the United States Supreme Court, to set Supreme Court precedent by overruling a well-established doctrine. Whereas there may be scholarly articles written in law review, various law reviews, or people in the academic field criticizing dual sovereignty doctrine. In many instances, academic articles are written to generate academic debate. They're not controlling on the court and gives no instruction to the court as to how to deal with a given situation, and certainly not this particular situation. The court denies the motion. Next motion.
And if I may, before approaching the next motion, the court received some documents from an attorney yesterday. Just want not to forget that we're still seeking to review those documents when the court has a moment.
Yes, sir.
We won't ask you to overturn the Supreme Court, Judge. Judge, this is on the defense motion for change of venue. I'm sorry. You're gonna need to take. Thank you. Judge, back in Lyndon Johnson's days, there was a case called Estes versus the State of Texas, which reached the Supreme Court in 1965. And in that case, the court said that the most fundamental of all freedoms, which must be maintained at all costs, is the right of a defendant to a fair trial. In the Ronald Reagan days, the Supreme Court revisited that and said that no right ranks higher than the right of an accused to a fair trial. And it is in those words that we bring forward today's request for the court to consider removing this trial from Charleston County juries and giving it to another appropriate South Carolina state.
Where would you like for it to go?
Well, Your Honor, I think that the area that we would like it to go is the area where there has been the least amount of polluted, incomplete, unreliable, false media coverage.
Where is that?
Pickens, Union, Edgefield, Marion, areas where there is not the type of media coverage that you would find in Charleston, Berkeley, Dorchester, Richmond, Kershaw, Lexington, Spartanburg, Greenville. If I may, Your Honor, continue on that without designating a particular location. The publicity in this case is a challenge for the defense on two bases. One is that it is nearly immeasurable in the saturation to the jurors in Charleston County. We have previously provided the court with an affidavit of a survey which was conducted last month, indicating 85% of the public is aware of this case. The jury panel, which the clerk called on Monday, the percentages were much higher. 100% of those jurors who showed up on Monday knew about this case. Over 95% of the jurors that were called to court this Monday had seen a video of the alleged incident, which is the subject of this charge. So it's not just the availability of the media coverage, but it's the intensity, the scrutiny of that media coverage, and the false narrative that has been promulgated initially with law enforcement in the name of Director Keel of the State Law Enforcement Division, in the name of the Chief of Police, Mr. Driggers of North Charleston Police Department, in the name of the Mayor of North Charleston, Mayor Summey, in the names of Wendell Gilliard and a number of other state representatives, Todd Rutherford, Justin Bamberg, and others, in the name of state senators, in the name of the United States senators, in the governor of South Carolina, the false narrative was repeated in the State of the Union address, by the President of the United States, who singled out the Scott family when he came in July of 2015 to visit with the Emmanuel victims and survivors. The key to this, we believe, Your Honor, is the video. And we would like to present testimony about the video and why we believe that the voir dire that was initiated by this court, that is in this court's direction, was not of sufficient depth to know something beyond the surface information that has been elicited. And we would like to start that by calling Alicia Ward.
All right, may come forward.
You swear affirm the testimony you shall give the board will be the truth, the whole truth, and nothing but the truth, so help you God? Please state your first and last name, and spell your last name loudly, clearly, and correctly.
Alicia Ward, W-A-R-D.
Good afternoon, Ms. Ward.
Good afternoon.
You are a resident of Charleston County, live in this community,
I do live in the community. I'm a resident of Berkeley County.
and how long have you lived in this community?
I have lived here for over 30 years.
And can you give us a little bit about your current occupation?
Yes, I own my own consulting firm, Ward Communications. I specialize in communications, marketing, and public relations, media relations, community relations.
How about, if you have an education background that has contributed to your knowledge
Yes.
of this area?
I have a degree in journalism from the University of South Carolina with a specialization in public relations and advertising. For 10 years, I worked as the Director of Marketing and Communications for Motley Rice Law Firm. And for another 7 years, I worked as the Director of Communications and Public Relations for the local CPA firm, Gamble, Gibbons & Moody.
Do you have familiarity with judging the intensity of media coverage of events in our community?
Yes.
Tell the court, if you would, about how you go about doing it. Well, first of all, have you been hired by Mr. Slager, his defense team,
Yes.
and for what purpose?
To really monitor and measure the footprint of the media exposure in this particular case.
And you have been engaged in that process for several months?
Several months, about 6 months now.
And tell the court, if you would, how you go about your business to provide your opinion to the defense team and for what purpose?
Well, the process, I use a variety of media monitoring services to be able to track those and see the media, Meltwater, Custom Scoop, Cision. I also do independent internet searches as well as social media research, as well as manual review to make sure that certain keywords, are removed. And then also, I reviewed in detail the subpoenaed data in this case.
I'm going to ask you just to talk like you're from the South and not from New York. If you just slow it down just a little
Okay.
bit. So you looked in, you said something about keywords. Tell the court what that means, keywords.
Keywords are search terms that are used mainly on the internet. So from a media standpoint, when stories are being written and published, those are terms that can then be used in a search, maybe a Google search, for example.
So if maybe a little more history would be beneficial. So you are familiar through your work with our office, different decisions of the South Carolina Supreme Court with respect to media saturation.
Yes.
And if some of those cases arise from incidents that occurred in the 1980s or 1990s, and I'm thinking the Bixby case in particular, what change in the media environment, the more general changes in the media environment have occurred since those decisions were made?
So the Bixby case would not have had the impact that this particular case does based on the current existence and use of social media. For example, reporters today use social media often. Broadcasters, print, radio, all use their social platforms to then enhance the story with the goal of more coverage, which leads to more interaction, more engagement. The Bixby case would not have had that much in social media involved in it. With it happening in approximately 2003, I believe.
So there was an event that occurred in the aughts, in the 2000 to 2009 time frame, which was of significance in news coverage, media distribution of news. Could you tell the court what occurred in 2007?
2007 was when the first smartphone was introduced, and really, in my opinion, began to change the way that news was consumed by readers and viewers, and also how news was written, published, and distributed, and not just the written word, but the graphics that would go along with it, whether it be photos or videos.
And could you tell the court approximately when the newspaper industry started incorporating electronic media as a prime source of news distribution?
From an internet standpoint, I would say early on. that they immediately began publishing that. But from a social media standpoint, I would have to do more research to give you an exact date on that.
Give us an example of things that a newspaper does today that they wouldn't have done 5 years ago or 10 years ago.
Well, again, on the social media aspect, you have reporters who are able to, live stream on their Facebook page, being driven to court, walking to court this morning. I was able to find out, that we had a New York Times reporter in the office from a Twitter feed. So Twitter, which wasn't around, now allows reporters to provide consumers with headlines immediately, also with graphics immediately. So I feel like this helps with the saturation of coverage of a case like this. You then, not only on the social media platforms, but then on the web of the news organizations as well. The invention of the iPhone and the tablet has also, in my opinion, had the impact of even changing how all organizations, but even media organizations, design their websites. Responsive design wasn't around 7 years ago, and now most all organizations, especially daily newspapers, for example, would have a responsive website, which then means that it would shrink to make it easier to get the news.
So in times not too distant past, in Charleston, we had a morning paper, an evening paper, 3 local channels, and 1 public broadcasting television station. Is that correct?
Yes.
And then on the electronic media, the televisions, how often would the news be broadcast at that time? For what period of time? How often?
Just the morning, usually an hour in the afternoon, and then your 2 evenings.
And how has the actual broadcast, the television broadcast in terms of coverage changed?
With the new platforms, they've had the ability to not have to have a full camera and a full crew to be able to report. Today, you can use your phone and get great quality video. You can post it from the hallway here up to a social platform and even to a website.
Has the news changed from television reporting from 6 to 6:30 to 24/7?
I believe so.
Well, whatever you believe, is that a fact?
It has over the last several years, yes.
So anecdotally, when you were sitting waiting to testify, did you notice how many people had iPads and cell phones and were communicating in the courtroom? Or looking at their iPhones or iPads today?
Outside of the courtroom, yes.
And in the courtroom?
I haven't seen anyone in here looking at their phone.
And in the hallway outside, was there anybody without an iPhone or an iPad?
Not that I saw.
Now, the information that can be passed on by the media is both in a printed form, electronic printing, as well as a video. Is that correct?
Correct.
And when I say video, I mean optical images of either still pictures or video.
Correct.
Who has the authority to control the type of written communication electronically or the optical images that are transferred? Who controls that stream of information?
Well, I think it varies. I would say that on an individual journalist's social media page, that they would control what they post, what images and what they write based on their standards that they uphold as journalists. From a print version, I do think that a traditional standard is still in place of an editor, chief and editor.
So within the media itself, there's some ethical standards of journalism. Is that correct?
Yes.
Now, how about the communication through social media and all those different Twitter things that you were talking about? Who controls the video or data information that's sent via social media?
The individual users control the data on their individual pages.
And is that limited in any way to the people who own the devices that can transfer that information? In other words, I have an iPhone. Can I choose what to send out regardless of what the Post and Courier or the New York Times says? I can communicate with my friends and family and people worldwide on what I choose to send them.
No, self-publishing is something that has definitely added to the media, but you cannot post anything that you would like on the Post and Courier, for example's webpage.
It's not what I asked. The question is, if I have an iPad and I want to send communications to third parties, am I the editor? Can I edit what I want to send? If I want to send a picture of a selfie with me and my wife, or with my dog,
Absolutely.
or I want to send a video of an alleged murder of North Charleston, can I send that and edit it before I send it?
Yes,
No question about that.
no question about that.
So in this case, you're familiar that there was a video that's purported to be of the incident, which is the charge misconduct.
Yes,
Have you seen the video?
yes,
Have you seen the video that has been released by the media?
yes.
Is the video complete?
I do not believe so.
You tell the court why what do they call it, the mainstream media, in its dissemination of this video, has, with alleged ethical standards, portrayed that video as being complete, or has it been portrayed as incomplete?
I'm sorry, what was the question again?
You had indicated earlier that the mainstream media has ethical standards, is that correct?
Yes,
Mr. Savage, this witness is being offered as an expert witness in some field, or fact witness in some field, or what is she being offered?
She has been offered as an expert witness in media.
And you're now also soliciting her opinion, testimony concerning the facts of this case?
No, not facts of this case. I'm eliciting her opinion on media coverage of the facts of this case. Her proposed testimony, Your Honor, is not to do about the facts of this case. It has to do with her opinion of how this case has been covered by the media, the saturation of that coverage, the penetration of the jury pool, and the human experience of, maybe she can't get into this, of bias as a result of repeated misinformation about the facts.
And you're proposing her as an expert specifically in what field?
Media field.
In the media field?
Yes.
Based on what education, training, experience?
Education, journalism school, and her life's work to date.
Counsel?
Judge, we think, based on prior testimony, that most of her expertise lies in public relations and marketing. Not looking to hinder Mr. Savage up to this point. We think most of the testimony has been fine, but getting into opinions about, impacts on psychology and things of that nature would be improper.
No, I'll refrain from asking it.
No.
With respect to your understanding from your academic training, your experience with the media, are there certain standards that the mainstream media has with respect to reporting the news?
yes,
With respect to your understanding of how social media works, the exchange of information from individuals not employed in the mainstream media, are there ethical standards?
on each individual who
Yes.
could, I couldn't comment on each individual.
Do you know of any organization for people who own a cell phone that they attest to certain standards in the information they send out?
No.
Has it been your experience specifically in this case to see the video, alleged video coverage of this incident?
Yes.
Have you been made aware of the entirety of the video that was taken by Mr. Santana?
Yes.
Has that been disseminated by the media in full?
No.
Have you seen any instances where it's been disseminated by individuals on various social media platforms?
Yes.
And the media or the media distribution by individuals has been greater or less than what has been distributed by the mainstream media?
And the mainstream media has had a lot of coverage and sharing of the video.
It's not the question. The question is the video. Has there been a more extensive distribution of that video in terms of length and what you can see by the mainstream media or individuals?
I'm going to object. I'm not sure that the answer is knowable. Are we attesting that she's seen every dissemination of this video by the media or otherwise?
I sustain the objection.
Have you seen the local television coverage of this video?
Yes.
Is it complete?
No.
Does it fail to show any of the participation of the two gentlemen prior to the shooting?
No.
Does it show the 8 shots?
Yes.
Is the impression provided by the local media, television, and national television that that's the complete story?
Yes.
Has it been covered in the Post and Courier? Have you examined the number of times it's been posted in the Post and Courier?
Yes, it's been excessively covered in the Post and Courier, approximately 1,800 mentions of the case.
1,800 mentions of Slager and Scott?
Correct,
That would be over 3 a day since the incident date?
approximately.
And that covers the print newspaper, 1 edition a day?
Print, along with their website.
And in the website, there are repeated electronic editions?
Correct, and then some of the articles have been included on their social media platforms.
Is there, such as Facebook and those type of things?
Correct.
Twitter?
Twitter.
And there's something called a pull down. What is that?
They also, the Post and Courier also has a special pull down section under news that is a subsection called Walter Scott.
Would you say that the same method of distribution is used by the electronic media, the 3 stations that govern the Charleston market?
Yes.
So in terms of the distribution of the story, the various platforms that are used by it?
Yes.
So it's not just a television show, it's a lot else?
Correct. The TV stations, local TV stations, data shows that they have also aired their broadcast on the TV, but then they've also promoted those stories on social media and their webpage.
Have they been used with other national or local stories?
Yes. A big issue that I've seen in this case is what I would call compounding, and it's really intensified the media on this specific case. Anytime an unrelated police shooting has occurred in our country, I've found that the local media then report on that, adding localization by including keywords such as Michael Slager and Walter Scott in the print and web and social media.
Would you give me examples, if you have any, of other police shootings involving a white policeman and a black male so-called suspect? Is that what you're referring to?
Yes, police shootings that occur with, I mean, Charlotte was black gentleman and a black gentleman, and the coverage still occurred in the same compounding fashion.
And when you say compounding, when there are reports of national incidents, they link it to a local story, the local story here being Slager.
Correct.
With respect to non-criminal events arising from the April 4th incident, have there been reports of a civil settlement?
Yes.
And what is the extent of that coverage?
There's been extensive coverage in print, broadcast, and social media of the civil settlement that had occurred.
Has there been coverage of a federal indictment?
Yes.
And
The federal indictment has been covered, many other issues, comments from Justin Bamberg, Brady Hare, Sandy Sin, as you mentioned earlier, our governor, our president. There have been many issues not related to the state case that have been printed and publicized and consumed.
well, let me ask you, starting with Brady Hare, who is he?
Mr. Hare is involved in the case.
Is he the lawyer for the city of North Charleston involved in the civil settlement?
Yes,
Is Sandy Sen the lawyer involved in the civil settlement?
yes,
Is Justin Bamberg involved in the civil settlement?
yes, he's an attorney.
And have they been covered in the news media of the civil settlement?
Yes,
Is there a gentleman by the name of Chris Stewart who's been covered in the civil settlement?
yes, his name has been covered.
Is the name Eric Plum been mentioned in the media on the federal indictment?
Yes,
Did the attorney for the city of North Charleston, Mr. Brady Hare, give a reason for the civil settlement?
Objection, Your Honor, relevance to this motion.
Sustain the objection.
Your Honor, the purpose of this is to show the extensive prejudicial
I
publicity.
understand the purpose of the hearing, it's a motion for change of venue. The objection is sustained.
Have all those attorneys commented, the attorneys that were asked to be questioned of this plenary as participants in collateral matters that arose from the incident of April 4th?
yes, they've commented.
Can you give me the number of, statistically, how this case compares to other high publicity matters of crime in Charleston, South Carolina?
Some research shows that comparatives to other high-profile cases in the Charleston County, specifically the Post and Courier, the Al Parrish case only rendered about 144 stories. The Kate Waring, about 63. The Skipperville case, 244. And then the Sofa Superstore, which is a high-profile case, for 175.
Let me go through those with you. The Sofa Superstore is the death of the 9 firemen.
Correct.
The Skipperville is the child molester of some kind.
Correct.
Al Parrish is the financier.
Yes.
And Kate Waring was the missing victim in the murder.
Correct.
Are there any crime stories or any court stories that you found that received half as much publicity as has been produced in this case?
My research shows specifically looking at one of the cases that it garnered about 525,000 hits versus this one at 1,430,000.
And what story was that?
That was Trayvon Martin.
Trayvon Martin received 1/3 the hits that this story has.
The shooting of Trayvon Martin as a keyword, yes.
Thank you for this indulgence. One area I failed to ask you about was radio media news reporting.
Yes, radio has also covered the story intensively and have also covered that, and posted it on their social media pages as well.
I'll answer any questions, prosecutor.
By state.
Thank you, Your Honor. Ms. Ward, good afternoon.
Hi.
Thank you. Your testimony began by sort of I think an explanation most of us are at least somewhat aware of, and that's a change in the media landscape to include smartphones and web access, and things of that nature. Is that correct?
Correct.
This technology we have here in Charleston,
Yes.
right? Do they have it in Edgefield County,
Yes.
Pickens County,
Yes.
Marion County,
Yes.
Berkeley County?
Yes.
Okay. Mr. Savage asked you about the authority or sort of editorial control over videos, and you mentioned how, respectable media outlets might use some sort of ethical standards, whereas, in-source, just single-source users might not follow those standards and send them to one another, right?
Correct.
And that can be a problem here in Charleston, right? As far as the fairness of how an event is depicted.
Yes.
Is that also a problem in Edgefield County,
Yes.
Pickens County,
Yes.
Richland County,
Yes.
Marion County?
Yes.
Mainstream media mentions, is it not true that one of the things about media being so accessible now via internet is sort of an end of media borders? In other words, if I want to read the state newspaper in Columbia, I can read that on my smartphone, correct?
Correct.
Right, so media saturation tends to be more, would you agree, more of a nationwide occurrence at this point, right?
Yes.
And so all of the things that Mr. Savage asked you about, all of this media getting up and drop-down menus and website hits and things of that nature, those hits can be occurring all over the nation, in fact, all over the world. Is that correct?
Specifically to one specific website, like the Post and Couriers,
Sure. I mean,
Yes.
you don't know where those hits are coming from geographically, correct?
they could from their Google Analytics.
And you studied those analytics?
I have not.
Okay. So a hit to say a story on the Post and Courier can be coming from Melbourne, Australia, Bern,
Correct.
Switzerland,
Yes.
Berkeley County,
Correct.
Edgefield County,
Correct.
Marion County.
Yes.
And would you not agree that in this day and age of sort of universally accessible media, a change from, say, Charleston County to Berkeley County may not have much of a difference as far as access to media is concerned?
I mean, my assessment is really assessing the local landscape here and the saturation of the media here, not in a different county. I would need to study that and its statistics to answer that.
Right, so your testimony is, if I were to ask you, how does local media saturation of these events compare to local media saturation of these events in, say, Columbia or Edgefield or Marion, your answer, being an honest person, would be, I have no idea.
I would have to research that.
Right. But based on your expertise, you can at least generally testify that the modern landscape of media makes most of these things accessible to anyone with a smartphone.
Yes.
And so generally speaking, in comparison, you mentioned some cases in the 80s and 90s, say, you made specific reference to some older cases in the 80s and 90s, that a case happening today, a change of going 100 miles up the road might not be as big of an impact as far as media exposure as it was back in the 1980s.
The landscape of media was very different in the 80s and 90s than it is today.
All right, and so maybe to articulate that better, back in the 80s, the news a person might get in Charleston might be real different than the news a person gets in Orangeburg, is that correct?
Correct.
And today, while it might still be different, due to the internet and smartphones and all the things you discussed, most likely it's less different than it would be back in the 80s.
Correct.
Thus, the change of a jury panel from, say, Charleston to Orangeburg would be less meaningful as far as media saturation than it would have been back in the 80s.
Correct.
I want to talk a little bit about your work. Did you rely on any sort of scientific method, scientific treatises or studies in conducting this media research?
There was some research, yes, that I did with the Pew Research Center. There was some stats from that I utilized.
And what statistics were there?
Specifically about U.S. adults and how many are using Facebook to get their news. Of those 64%, about 30% are getting their news from there. And those regular users said the type of news specifically that they wanted was 73% entertainment and 65% about people and events in their local community.
Okay. But as far as judging the media footprint or whatever, did you use like a scientific method? Do you know that you're accessing all of the media coverage, or are you just sort of doing like any user would and sitting at a computer and reading some articles?
No, the media monitoring tools are pretty standard in our journalism industry of Cision and Meltwater and Custom Scoop. So these are media monitoring tools that are subscribed to within the industry.
And did it just work like alerts? You might put in keywords and they'll inform you of when an article is published on that?
You can use it for that, but from a research standpoint, you would use it differently. You wouldn't get alerts. You would use their database for research. And then I use multiple ones to be able to compare the data. And then along with the public searches that are available, Westlaw research as well.
Okay. Mr. Savage had you refer to two cases that you familiarized yourself with that happened in the 80s and 90s. Did I understand your direct testimony?
I'm confused on which one you mean.
At one point, Mr. Savage asked if you had read Supreme Court law in relation to publicity, and you said yes. And you said, I'm not putting words in your mouth, I believe you said, yeah, but those cases were from the 80s and 90s. Is that correct?
Bixby was
Yeah.
one that we talked about. That is a 2003 case.
It's 2003?
The incident was 2003. The actual trial was October, I think, of 07.
Of 07, okay. Did he familiarize you with Evans
No,
or Shepherd versus State?
no.
And wouldn't the end determination be a voir dire of the jury as to how many jury members have been exposed to this publicity, right?
Yes,
And are you familiar that the standard is not whether or not they've been exposed to it, but whether or not they can put those opinions aside and listen to the evidence?
yes.
Court's adjourned. I have nothing further here.
You know it.
Nothing further.
Thank you.
Defense calls Andrew Knapp.
I'd like to approach along with counsel.